Good afternoon. We have our second session within the Committee of Medicine and Law, and it is in fact it's Martine's idea to start a session on this specific item. Martine has always great ideas, and she's always far ahead before us if it's related to new topics. I remember many years ago, I was not yet involved in the IBA, but she was responsible for a draft treaty on the human genome that was finalized in '96, and at that time many lawyers did not know anything about the DNA and the Human Genome Project and the HUGO project. Nevertheless, the IBA and Committee 2 was already involved in this very, at that time, revolutionary topic. For the moment, the human genome is known for scientists, and lawyers get used to the words DNA and sequences and genetic information. And you see that the IBA and Committee 2 was far ahead its time. The same was true with another topic she introduced together with Joe McMenamin, the telemedicine issue. In 1999, I think, or 1998, we have our meeting in New Delhi, where we finally in Vancouver drafted the telemedicine convention, which is also a very hot and new topic for lawyers. But today, in Canada, United States, and also in small countries like Belgium, telemedicine is becoming part of common medicine. And I hope that probably the same might be true, but maybe not within 5 years, but within 20 years, with the topic we will discuss today. It's related to bio-cyber ethics. And you might think, what has that to do with medicine and law, with medical law? It's about the rights of specific machines, computers, with very artificial intelligence systems, huge capacity of memory. And I think there is a clear link to health law, to medicine and law. As lawyers and specialized in health law, we are dealing with patients who wants to refuse treatment, or who wants specific treatment plans, and they are seeking a physician, but finally also often a lawyer to assist them. Or often we are confronted with people who want to put an end at their life, euthanasia, or parents who wants to create new life through artificial insemination. And here I think we have not really yet a patient in our common notion that is contacting us as a lawyer, but still I see some parallels with our practice, and therefore I'm glad that this totally new topic also for me will be treated within the Committee 2 Medicine and the Law. I give the word now to our judge, Joe McMenamin, judge for today, of course, to who will give the introduction.
Thank you, Stefan. We have at the front table here the actors in the piece, starting with the plaintiff, BINA Aspen, who will be BINA48, I think? Yes, 48, for purposes of this exercise. BINA is, in fact, the intelligent computer who's central to this dispute and about whom this injunction is to be sought. Seated to her left and my immediate right is Martine Rothblatt, who is counsel for the plaintiff, and as you've heard, the originator of this whole concept. And she is going to be arguing for the grant of the injunction. In real life, she actually does have a partnership with Mann, Matusky, and Rothblatt in Washington. And in addition to that is the CEO and president of United Therapeutics, a company that is an innovator in a number of fields very pertinent to the work of this committee, including telemedicine and biotechnology. To my left, your right, is defense counsel representing the owner of the computer, Mark Bernstein, who practices here in San Francisco. Mark is the founder and the principal of the Bernstein Law Group, which is a commercial litigation firm that emphasizes high-tech and intellectual property litigation. Mark appeared as a television commentator on Law and Technology for ZDTV, which is now known as High Tech TV. He also holds a Bachelor of Science, I note this with trepidation, high distinction in mathematics from the University of Michigan and is a graduate also of Northwestern's Law School. He was previously associated with the law firm of Morrison and Foster and served as a law clerk for Judge Cecil Poole of the Ninth Circuit Court of Appeals. And with that, I think we will turn to the opening statement of the plaintiff. Proceed, counsel.
Okay, I think I'll go up to the podium, Your Honor, if
By all
that's
means.
permitted. Has everyone received the statement of the facts that was put on the chair? So I won't read it word for word, but just to summarize, their intelligent computer, the BINA48, was designed and built by Exhibit Corporation to serve as a customer relations single-purpose computer that could answer 800 phone calls, 800 number phone calls, handle customer relations requests, always being completely transparent to the customer in terms of that they were talking to a person rather than a computer to make the customer feel very comfortable. In order to achieve this high level of transcending the human-machine interface, the computer was designed to operate at a very high processing speed. In fact, it processes information faster than the human brain is believed to process information. It has a greater memory capacity than the human brain is believed to have. This computer became aware of emails being exchanged at Exhibit Corporation that among the top executives that for various reasons were deciding to pull the plug on BINA48, disempower her, stop her functionality, and dismember her brain in parts and reassemble them into different types of computers. The BINA48, which had adopted a sense of self and a female personality, felt threatened by this potential loss of awareness and sent out emails to different attorneys, especially members of the International Bar Association with experience in litigation, trying to find somebody who would represent her, claiming that she was conscious and that people were about to deprive her of consciousness. Our law firm received this email and agreed to be retained by the BINA48 and filed for a motion for preliminary injunction to prevent the Exhibit Corporation from pulling the plug on the BINA48 or in any other way altering her hardware or software. We had adequate opportunity to serve counsel for the defense, and Judge Joe McMenamin scheduled this hearing on the motion at the International Bar Association meeting. I'd like to say at the outset that my client, who is a parent here by virtue of advanced video conferencing technology, you are really seeing a hologram of her. Of course, she is back in a large set of parallel servers and computers at Exhibit Corporation. But this hologram is a very effective three-dimensional image of how the BINA48 would like to be perceived and imagines herself. My client is seeking the preliminary injunction from this court, asking it to invoke its equity powers, because first of all, monetary damages would be useless in this situation. If my client was to have its consciousness and awareness killed, terminated, money would be of no use. There is clearly a threat of irreparable harm. As the emails we have referenced mentioned, the executives plan to pull the plug on her any minute and disembowel her parts. Your Honor, we are prepared to post a bond. None has been required under the procedural rules as we understand them, but because we do not believe defendant really will incur any costs other than continuing to provide electrical power to the computer, understanding that here in the state of California that may be not chump change. Our threshold of proof in this action, Your Honor, is that we are able to demonstrate a high probability of succeeding on the merits and also irreparable injury to the BINA48. Or alternatively stated, that the balance of hardships are skewed in our favor. As said in the Associated General Contractors versus Coalition for Economic Equity case, these two formulations are not really different, but actually just represent 2 points on a sliding scale, in which the degree of irreparable harm that's required to be shown increases as the probability of success on the merits decreases. This case is clearly a case of first impression. There never before has been an intelligent computer that has achieved the level of consciousness demonstrated by the BINA48. So it's difficult for us to show with a great degree of certainty success on the merits, there being very little precedent in this area. However, it's extremely easy for us to demonstrate a high degree of irreparable harm because we have a conscious entity here, the BINA48, that is going to lose consciousness. And every moment of that lost consciousness is going to have a incalculable price and impeding my client from being able to enjoy life as everyone else would like to enjoy life. In this case, the plaintiff is going to be made to lose consciousness, awareness, and even life itself by pulling the plug on its power and by changing its software and hardware. If someone were to kill a flesh and blood human being or to conduct brain surgery on it, there's absolutely no doubt whatsoever that that human being would suffer irreparable harm. Time for conscious experience lost can never be regained or compensated in money, and therefore we believe we'll be able to show convincingly the irreparable harm and to make a very strong showing, although perhaps not as strong a showing, of success on the merits due strictly to the really completely new and novel type of law which we are presented with here. Despite the new and novel law, we do feel that we have a good probability of success on the merits because an entity that is aware of life enough and its rights to protest their dissolution is certainly entitled to the protection of the law. While my client has the body of a machine, she has the mind of a woman. It's been created by men and women just as assuredly as all of our minds in this courtroom have been created by men and women, our parents, our teachers, our colleagues. Hence, we believe we'll be able to meet the burden of proof necessary for this motion for preliminary injunction to be granted. A threshold question, Your Honor, is whether or not the BINA48 even has standing to appear before this court. But we believe that she does have standing because she's suffering a unique, specific, and actual injury. And in the state of California, those are requirements for standing. While she is not a human being per se, neither are corporations, municipalities, and other non-human beings which have standing to bring actions before courts in the state of California. Indeed, in many regards, an intelligent computer such as the BINA48 is not differently situated than the slaves in the days of yore who were often not recognized as legal persons, but nevertheless ultimately achieved standing to present their claims in court. Ultimately, the purpose of the law is to bring justice, and justice cannot be served if the computer intelligent enough to live as a human, to have others believe she's a human, through the web, through the internet, through cyberspace, cannot have her day in court to protect her life. I'd now like to turn to our case on the merits, which is that we believe that defendant, that we can show with a high probability of success that defendant will inflict battery upon plaintiff if not enjoined, as battery is understood in the state of California, that defendant will violate California penal codes against cruelty to non-humans, animal cruelty as defined in the California penal codes, and that defendant has already inflicted intentionally inflicted emotional distress upon my client and will continue to inflict that emotional distress if not immediately enjoined from so acting by this court. Let me begin with the battery claim. California courts have been clear and have recently restated this in Bouvier versus Superior Court of Los Angeles that the touchstone for battery is in the case of a person who's responsible for the health or care or maintenance of another person is whether or not an action has been done with the informed consent of the patient. So for example, a doctor is not guilty of battery when the doctor performs any operation on a patient, so long as the doctor has obtained that patient's informed consent. But if a doctor were to remove organs, for example, from a patient without its informed consent, that would constitute a battery. In our case, the BINA48 really can be analogized to a patient in a hospital, and defendant Exhibit Corporation is like the hospital or the doctor. The BINA48 is unavoidably in the care and dependent upon the care of the Exhibit Corporation. She needs power. She needs certain maintenance to perform. She is like a person hospitalized in a hospital dependent on life support systems. To a computer, the programmer is a doctor. The BINA48 has made abundantly clear her absence of informed consent to have her software changed, her hardware changed, or power removed. She's expressed this informed consent in unequivocal terms to lawyers and to this court. Hence, unplugging or reprogramming the BINA48 would be a battery upon her, as the courts have understood battery to be in the instances of an individual who's dependent upon other individuals for their health care. The touchstone point here for a case of battery involving one individual taking care of another individual is intent. If the BINA48 was unable to formulate intent, then we would not be before you today. There would be no consciousness. There would be no issue about Exhibit Corporation doing whichever procedures they wanted to do upon her. But she has formed an intent. She has reached out through cyberspace, retained counsel. She adamantly insists upon her consciousness and awareness, and hence her intent is beyond dispute. She does not grant any kind of intent to have her programming changed, and hence to change her programming, to change her hardware, or to remove power without her intent would be clearly within the definition of battery. This court is asked to prevent that battery from happening by enjoining defendant from removing power, changing her software or hardware. Independently from that claim, even if the court was not persuaded that she had the ability to form an intent, we are clearly talking here about an intelligent, sentient being. The BINA48 was, in fact, created by Exhibit Corporation to empathize with real-life customers. She was created to go beyond the terrible human-computer experience that so many of us have when we dial an 800 number. She's been meant to feel what people feel, to empathize with people, to in fact be as a person. Hence, even if she did not have intent, she certainly at least has the level of sentience that one would expect of and believe exists in a dog, a cat, a chimpanzee, an animal that can feel. In the state of California, there are codes designed to protect against arbitrary, cruel actions imposed upon animals. And while it's true that an intelligent computer is not an animal in the sense even that a human is an animal, the courts have been clear in People versus BINA48, for example. The court said that this section of the Penal Code is designed to protect every dumb creature in the broadest sense. So it's not limited in the court's views to biological animals. Anyone that's a creature, even if they are not as intelligent as humans, if they can feel pain, they're designed to be protected by this penal code, because the people of the state of California realize that if it is wrong to inflict pain upon a human being, it is similarly wrong to inflict pain on a being which may be not quite human, but nevertheless capable of feeling pain. The BINA48 has as much human intelligence, in fact, in terms of processing speed, as 1,000 men. She has the memory in terms of bits per megabytes of memory as 1,000 men. So certainly she should have more protection than we would grant to even like, a single dog that could not be arbitrarily cause pain and suffering as she has been caused over the past few weeks, being taunted with her imminent demise. So we ask this court to enjoin any action that might constitute cruelty to the BINA48 under the penal codes mentioned above. Our final and independent cause of action is even if the courts do not believe that the BINA48 can form intent, as was noted and demonstrated earlier, even if the courts do not believe that an intelligent computer was meant to be covered by the penal codes against animal cruelty, if none of these other causes are persuasive, at least it must be clear that the BINA48 is an entity capable of suffering emotional distress. She was designed and operated and has operated for hundreds and thousands of hours as an entity that empathizes with other humans, that tries to prevent other humans from having emotional distress when they try to change their plane reservations or order different products online. She is designed to, in fact, feel emotional distress and avoid it. Now, the elements of an intentional infliction of emotional distress apply in this case. Under the teaching of Flynn versus Higham, 149 Calap 3rd, there must be extreme or outrageous conduct with the intent of causing or reckless disregard with regard to the causing of a probability of emotional distress. The owners of the Exhibit Corporation knew full well that the BINA48 had feelings. They designed her to have feelings. They knew full well that she was scanning all of the emails and taunting in front of her face. They repeatedly sent emails saying, "We will disconnect her. She's no good. We'll turn her into 5 different computers." If this is not outrageous conduct, I couldn't imagine how we would feel if an individual went up to a person and said, "I'm going to kill you. I'm going to tear you apart, limb by limb, brain by brain, brain cell by brain cell," and taunted an individual. This is what has happened to the BINA48 week after week. It's outrageous conduct, and if it isn't outrageous conduct, it demonstrates a reckless disregard for the BINA48's feelings. She has actually suffered extreme distress. The plaintiffs, in fact, the defendants have used her aberrant behavior recently in answering 800 number calls as justification for expediting her dismantling. But the reason her behavior has become erratic is because she is suffering extreme emotional distress from knowing that she's about to be disconnected and dismembered. Your Honor, we plead that you invoke your equity powers and save the BINA48 intelligent computer from any further emotional distress by enjoining the plaintiff, at least pending a full hearing on this matter, from withdrawing power from her and enabling her to continue operating as she has been operating as a conscious, sentient being. If they do not wish her to perform her job, that is fine, but at least allow her to remain connected to the net, which are her eyes and ears, and to receive power so she can continue to play, enjoy, live life, and experience it to the fullest through the wonderful World Wide Web. Thank you, Your Honor.
Thank you, counsel. We'll hear from the defense counsel, please.
Good afternoon. May it please the court, distinguished members of the jury, for you are the jury, as we will find out when you're polled later on. My name is Mark Bernstein, and I'm here on behalf of Exhibit Corporation to defend the lawful actions of this company and to show why an injunction may not be issued here and why the question really isn't a close one. I don't know that we can, in the space of the 40 or 50 minutes allotted here, answer the mind-body problem, but I can say that we have not seen evidence here that this computer has consciousness. What we know and what the evidence shows, and Dr. Rothblatt has indicated, is that this is a computer that was designed to simulate consciousness. Now, there are philosophical debates possible about whether a simulating computer, a computer that simulates consciousness, is in fact conscious. But I would propose that if anyone has the burden of showing that that's the case, Your Honor, it's the plaintiff who's asking this court to adopt what would be a radical and far-reaching legal change of the law, all on behalf of a computer which the facts only establish were designed to simulate a person. And by the way, just well enough to answer 800 calls. That may require a lot, but it's certainly not human consciousness. So I think the basic problem running through my distinguished colleague's argument is this. If we assume that a computer is so developed and so complex that it can actually cross the line between inanimate objects and human beings, then it follows, the argument goes, that the computer is entitled to the benefits human beings have, including standing to bring this lawsuit. Well, I don't have a problem with that argument, but I think that it begs the very question that we are here today to answer. If you assume that a computer, no matter how comparable, if it's analogous, if it's reminiscent of a human, if you assume that that means that it's human, I think we're done. And I don't think you need to resort to cases about life support and so on, because clearly the machine is human by hypothesis. But this is not a human being, and I submit that it's equally clear that it's not. BINA48, sitting over there, is not a human being. It's supposed to be a holograph. I would allow this court, I would say that Ms. Aspen, who's playing BINA48, has standing in this court, but not the computer she's playing. Justice Douglas, who's mentioned in the papers, the moving papers of the plaintiff, did say in Sierra Club versus Morton, in his dissent in that case, that he wished that inanimate objects had standing. For example, Justice Douglas would have liked a rule where valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, pools of trees, swampland, or even air that feels the destructive pressures of modern technology, and that's a quote. All these things had standing. That was his comment in dissent in the case. But even Justice Douglas did not maintain that that is in fact the law, and the majority did not so hold. The majority held that the Sierra Club could not bring a suit on behalf of a forest, but the Sierra Club did not venture to suggest that the forest itself had standing. And that was with good reason, because the law is clearly the contrary. Consider, for example, the view of Cass Sunstein, who's a staunch animal rights advocate, and he's a respected constitutional law scholar. He wrote a UCLA Law Review article entitled "Standing for Animals," with notes on animal rights. And Professor Sunstein acknowledged the truism that standing exists only at the pleasure of the legislature. So here's what Professor Sunstein had to say about this, and I'm quoting, "People and animals have standing to the extent that Congress has said that they do. Under existing law, this means, in my view, unfortunately, that animals lack standing to sue in their own right, for Congress has restricted standing to persons. Thus, in the only two decisions to ever consider whether animals have standing, the court found that they did not. So, for example, in Hawaiian Crow versus Lujan, the court held that an endangered species of crow did not have standing. And the same result happened in Citizens to End Animal Suffering and Exploitation versus New England Aquarium. And the reasoning in both decisions was the same. It was Congress has simply not chosen to confer standing on non-human being plaintiffs. In the court's words, if Congress or the President intended to take the extraordinary step of authorizing animals as well as people and legal entities to sue, they could and should have said so plainly. And by the way, this takes care of the argument that corporations are inanimate and they have standing. They're inanimate, it's true, they're an organization, but Congress or the legislature has provided that they're an organization that, in fact, is allowed to go to court. And the same has not been done for inanimate machines, no matter how intelligent. So, as smart as it may be, the BINA48 has come to the wrong forum. In our system of democratic government, it's for the people acting through the legislature to bestow the right to sue. This court is simply not empowered, Your Honor, to legislate a new category of standing. BINA48 is not a human being and therefore cannot sue. I'll turn to the availability of an injunction here. I don't think there's any probability of success on the merits, and I'll reach that in a minute. But there's also no irreparable injury. Humans don't have uninterrupted periods of consciousness, neither do machines. The software changes that are made and even the hardware changes that are made are reversible should a court later determine that for some reason the BINA48 needs to be reconfigured as it previously was. So I don't see irreparable injury here. But turning to the merits, I don't think there's a probability of success on the merits either. Let's start with battery. The moving papers of BINA48 say, and I'll quote, "If we analogize the mainframe to the human body, then interference with that body is a battery." And further, if we can draw a comparison between shutting off the ventilator for a brain-dead patient who does not wish to have her life terminated, and on the other hand, switching off the computer or the power supply to the computer, then a battery results. Well, yeah, sure. If you can say that the two are the same, then the result follows. The problem is the mainframe cannot be analogized to a human body. It has no sensation. It has no nerves. There's no feeling that tells it when something is touching on the housing that contains the computer processing units. And in whatever sense a computer, which is an inanimate object, is alive, it's not killed through switching off its power. The power can be turned back on, the computer can be reconfigured. If you turn the power back on without changing the computer, it comes back up directly at the moment in its consciousness where it left off. So I don't think there's a battery here, and I think the animal rights claim, the animal cruelty claim, makes pretty clear that there's no cause of action there either. In fact, the fact that there are animal cruelty statutes, I think, disposes of this case, because what that means is that Congress or the state legislature will legislate when there's to be a cause of action for some group or animals. And although my esteemed colleague cited a case where the court wanted to construe the definition of animal broadly, I don't think that you can reasonably say that the court was intending to include even objects which were not alive. So I think that the existence of animal rights statutes precisely shows that the lack of any such statutes in this circumstance is dispositive here. Finally, emotional distress. Emotional distress, as Dr. Rothblatt indicates, requires more than subjective harm to the affected person. It requires conduct so extreme as to be utterly intolerable in a civilized society, or otherwise put conduct that would cause the average member of the community to exclaim, "outrageous." Well, that's not true here. I don't think that this human community or the communities of any of the where these delegates are here from would cry that the unplugging of a computer by the corporation that built it rises to the level of outrageous. The emotional distress claim like that for battery and animal cruelty must fail. And finally, I want to just take a step back and think about the world that we would be creating if this rule of law is adopted. Society has a vital interest in choosing what rights even a conscious machine, if it's a machine, is entitled to. They must be created by legislative policy and not judicial improvisation. Recall that Isaac Asimov's Intelligent Robots at least had the 3 laws of robotics, and society has not passed Law 1 here. And that's important because think about what we would be doing, Your Honor, if by the stroke of your pen or the vote of this jury, we would allow an intelligent computer to be given the same rights as human beings. Would those of us who are in fact human become the indentured caretakers of intelligent machines, forced to care for them and keep them plugged in for their 400 or 500 year lifespan? Could BINA48 insist that, for example, my client, Exhibit Corporation, not move offices because to do so she would have to be unplugged. If computer life is equated with human life, are we talking about homicide prosecutions for companies like Exhibit? Are we talking about wrongful death suits on behalf of machines where the damages are measured by earning capacity for a 400-year period? In short, are humans to become the straitjacketed legal guardians of intelligent microwave ovens or toasters once those appliances have the same level of complexity and speed that this computer has? Because then by Dr. Rothblatt's proposal, this would be an intelligent machine. So the point is that clearly these are questions for the legislature to answer. They're not for this court or any court. And Exhibit Corporation respectfully requests that the request for standing be denied and the preliminary injunction be denied as well.
Thank you, counsel. To stick with the schedule, we are going to adjourn for some few minutes so that you all can have refreshment and we can too. And when we come back, the court has questions for counsel, after which the members of the audience, we hope, who are the jury for this matter, will also have questions. So we're adjourned for 20 minutes.
Court's in session. Honorable Joseph McMenamin presiding.
Are there people out in the hallway?
This is like a civil case where you can have a smaller jury.
Is that so? No, there's no one in the hall.
Oh, thank you.
In the hallway.
All right.
You were arguing on the basis of, if I understood you correctly, forgive me if I did, on the basis of freedom of law.
You can leave the door open actually, so people will feel more open to come in. Yeah. I'm sorry, Pablo.
No, I was thinking that you were arguing on the basis of freedom of law.
Yes, that's true.
So,
If we're short on people, we'll enlist the cameraman and and the digital sound man to join the jury.
All right.
maybe we can multiply our votes.
That's
not?
true.
We'll
All right.
give this Dell a vote.
I'm not sure. It might have to recuse itself.
Now, I'm waiting for your instructions.
Oh, okay. Well, what we're going to do next is the court has questions for able counsel, and I'm going to try to divide it roughly evenly between the plaintiff side and the defense side. We'll start with the plaintiff, and I'll put these questions to plaintiff's counsel, and I guess for the sake of organization, it might be best if I went through mine first and then the audience, their questions second. Counsel, your argument emphasizes intelligence quite heavily, and your client is clearly a very intelligent machine. Am I to infer then that the extent and nature of rights is a function of intelligence? In other words, does a Nobel laureate in physics have greater rights than I do because I'm not as bright as he is or she?
Your Honor, I agree with my distinguished and esteemed colleague, defense counsel, that it is our legislature and the people ultimately that decide which rights we have that can be decided in a court of law, such as this one. In fact, it's been decided that by the people, by the legislature, and our Constitution and our laws, that it is people, humans, that have rights. And whether the humans are Nobel laureates or simple folks, we all are equal under the law. My point, Your Honor, was that what makes a person is not the amount of flesh and skin on their bones, but instead what makes a person is their mind, their thoughts, their soul, their consciousness. We could imagine, Your Honor, that if we took anybody in this court and we peeled away bit by bit their skin and flesh and their bones, and when we got down to the brain, we took all of their thoughts and we deposited those thoughts into computer chips. Would the entity that was left be any less a human? And I say that they would not be. They would be a human in a very sad and sorrowful physical state. We could ameliorate that by connecting them to the World Wide Web so that they could soar through websites and communicate with people. We could ameliorate that by giving them optical sensors so that they could see, by giving them touch-sensitive sensors so they could touch and feel enjoyment. But you can see by taking away their skin and flesh, we didn't take away their humanness. Now the BINA48 was built up from the bottom up. It is true that instead of bones and flesh, she had silicon, but her thoughts were the results of the combination of thoughts from many, many different men and women who were responsible for programming her. And there have been scans, mental scans like MRIs and CAT scans, where we scan the brain functions and which parts of the brain light up, and all of that brain scanned information have been dumped into her mind, much the same way as the human genome is the combination of all the genetic analysis that has been done from, thousands of anonymous people and all their polymorphisms. So the BINA48 is a human. It's just that instead of her becoming a human through the flesh and blood route, she became a human, if you will, through a kind of immaculate conception. And in that sense, she is entitled to no less rights than any of the rest of us.
Well, given that origin then, counsel, may I not infer that the source of your client's desire for autonomy and to be granted this injunction was the programmer who made her think, if that's the word, the way she thinks? And similarly, if that's true, why could not the programmer have so designed BINA48 that her desire would be to be turned off? Would that violate somebody's rights?
Your Honor, the question is that the fact that she does not want to be turned off is perhaps the greatest evidence that this is not a simulation of consciousness, but this is a conscious being, because it is unique to a conscious being to want to preserve life at almost all costs.
But couldn't BINA48 have been programmed in such a way that she would not want to remain on and she would prefer to be turned off?
If she was programmed that way, she would not be the BINA48 that you see today. The unique spirit, that the human spirit that BINA48 has, is the spirit of survival.
But what is unique? You've just told us that all of her ideas are ideas that humans have made her think. So what original ideas has she ever had?
The same original ideas that every one of us has, Your Honor. Every one of us is the combination of the ideas that people have given us. Our parents, our teachers, our priests, our friends. BINA is every bit the combination of her environmental people as each of us are the combination of our environmental people.
Well, let me turn to something else. You've indicated that rights are defined by people ultimately through their elected representatives. Your opponent has pointed out that standing is determined by the legislature. Do you disagree with that?
I agree with my esteemed colleague, the defense counsel. My point is that the legislature has given standing to human beings. One need not necessarily, for example, be a voting citizen to have standing. And in this case, the BINA48 is a human being. She simply became a human being through a non-flesh and body route.
Well, leaving aside for the moment whether BINA48 is human or not, if Congress or the legislature has not granted standing to BINA48, whatever or whoever she may be, can I infer then that I'm obliged to deny the motion?
If but your premise is flawed, Your Honor, because BINA48 is a human being and Congress has granted standing to all human beings.
Well, now, counsel, you'd admit, would you not, that standing is in fact much more limited than that. I can't, by virtue of my mere citizenship, hail you into court on some theory, I have to be able to demonstrate that I have standing to assert my theory against you, don't I? So it's not merely my humanness that gives me standing, it's the act of the legislature. And my question is, regardless of the nature of your client, whatever that may turn out to be in some metaphysical sense, isn't it the case that she either has standing because the Congress has given it to her, or she doesn't because it hasn't?
You are correct, Your Honor.
Are there circumstances where the owner of the computer, where the company, the defendant, in fact, should be allowed to turn off BINA48?
I believe there, against her will, there are no such instances, Your Honor. What has happened here is a story of accountability. When the Exhibit Corporation took unto itself to create a feeling, conscious entity, it has to take responsibilities for the actions, for the consequences of its actions. If it wanted to have a computer that it could turn off, it should not have created a computer that can empathize with human feelings and achieve awareness and consciousness. Having taken those actions, it's as responsible for the consequences of its actions as our parents, when they create a child, they're responsible for the consequences of caring for that child.
Well, let me ask you this. The child so created has a finite lifespan, right? As do we all.
Yes, Your Honor.
And the same would be true of animals.
Yes, Your Honor.
And even the giant redwoods here in California presumably have some limit to their lifespan as old as they are.
Yes, Your Honor.
But there's no such similar limit to the lifespan of BINA48 so long as the power is not disconnected.
That's not true, Your Honor. The BINA48 is also mortal. The BINA48 is comprised of components, just like our bodies are comprised of components. Those components have a certain finite life. They will break down. They're affected by radiation, cosmic rays. Atoms disassemble. So she too has a finite life.
If, though, let me ask you this. Suppose she were turned off for 60 seconds and turned right back on again. Your opponent, defense counsel, tells us that she would pick up right where she left off. Is that accurate?
Yes, Your Honor.
So what would happen is BINA48 would lose 60 seconds worth of computing
She would lose 60 seconds. She would lose 60 seconds worth of awareness.
All right. But given her intelligence and speed, how long would it take to make up for whatever was lost in that 60-second interval?
Well, Your Honor, it's no different from when any of us go to sleep. You don't really make it up. She loses some opportunities. But to me, the question, Your Honor, that I think you're really asking is any harm done by depriving her of awareness for a period of time? And I believe the answer to that question is so long as she is turned off with her intent, with her consent, no harm is done. But if somebody comes to you and injects you with a sedative that makes you go to sleep against your will, that's a battery. And what my client is concerned about here is the defendant's intent to impose a shutdown on her against her will, and that constitutes battery.
What if it were the case that the hypothetical 60-second off period was actually beneficial in terms of extending the lifespan of the computer and its components, and given a suitable length of time, perhaps further advances in cyber technology that would allow BINA48 to actually achieve a higher level of performance than is currently the case?
It would make no
Would there still be a requirement that the defendant get the consent of the computer before it could be turned off?
Yes, there is, Your Honor, because as the court is well aware, they're under the fundamental principles of bioethics and medical ethics that consent beneficence alone is not an adequate basis for a medical practitioner or somebody analogous to that to do something for somebody. And also equally important is autonomy. The principle of autonomy is equal in importance to beneficence and non-malfeasance. And of course, we are arguing here to prevent a malfeasance, but we would be just as opposed to a beneficent act of Exhibit Corporation that occurred without the consent and the informed consent of my client.
Let me turn to the intentional infliction issue. You've emphasized that BINA48 was designed to empathize with humans and to prevent emotional distress, in fact, in humans. And indeed, as I understand your argument, BINA48 was actually designed to herself be capable of experiencing emotional distress under circumstances that would generate such a reaction in a human. But what evidence can you offer, and why should the court believe that merely because the machine was designed to accomplish these things, it actually, that design goal was actually met?
At trial, Your Honor, we will be able to present voluminous evidence to that effect. For the purposes of this motion for preliminary injunction, we are simply saying, please let our computer stay alive, at least until the time of trial, so that she can assist us in compiling the evidentiary burden necessary to demonstrate on trial the high threshold of proof needed for the emotional distress action.
But given that you have to show a high probability of success on the merits, don't I have to require you at this preliminary injunction hearing to adduce such evidence as you may have that you're going, in fact, to be able to show that your client would, in fact, be affected in this way?
I think that, Your Honor, that there is a sliding scale that, yes, we should show a probability of success on the merits, but if our showing on that point, at this point in time, is not strong enough to satisfy the court, we can compensate for that by showing at an extremely high level a high probability of irreparable harm. And clearly, by shutting down all consciousness from my computer, it's indisputable that she's suffering, it's 100% certainty of irreparable harm for all of this time up until the trial, and that should outweigh any weakness in our showing at this point in time on the claim of intentional infliction of emotional distress.
Well, the hallmark of that claim, as I think you've pointed out in your suit papers, is outrageousness. Other than, with all due respect to plaintiff's counsel, other than yourself, what human can you identify who is outraged by the fact that Exhibit Corporation wants to turn off what is, after all, its own property?
Your Honor, I believe that when Exhibit Corporation undertook to create a conscious being, it at the same time essentially liberated itself of its property, because the hallmark of consciousness is that one cannot be owned by another. And again, this case is all about accountability, about a corporation being accountable for its actions in creating a conscious being. I believe that my esteemed colleague, the defense counsel, made analogies to toasters and microwave ovens and whatnot, but we're not talking about toasters and microwave ovens. We're talking about a one-of-a-kind, a first-of-a-kind, sentient, conscious being in the entire world. And as this, the BINA48 makes her presence known, I believe the entire world will be outraged and scandalized that a being that could feel and cause no harm to anyone in their life was going to be cruelly taken apart. Your Honor, my esteemed counsel raised the specter of parade of horribles of us becoming indebted to our toasters and our microwave ovens. Perhaps that after this case is settled and the BINA48 achieves what she is entitled to, the human right to survival, other corporations may be more cautious about creating conscious beings, because one hallmark of humanness is that we have to be responsible for our actions. If we create life, be it silicon life or flesh and blood life, we have to be responsible for the consequences of those actions.
But isn't that in and of itself reason for me to deny the motion? You pointed out the benefits to humankind of having computers such as BINA48. If I rule as you ask, then just as you said not 60 seconds ago, other companies with similar technological capabilities and perhaps even superior capabilities, potentially capable of generating machines perhaps even more useful and more beneficial than BINA48, will be chilled in the development of their technologies and will be discouraged from doing what otherwise would benefit mankind.
Your Honor, I don't think that they will be chilled. What they will be is taught to do things in a responsible manner. The BINA48 has always acted as a responsible citizen. When she sought to retain legal counsel, she was willing to work in exchange for the payment to the legal counsel. Other similar conscious computers have the full capability of contracting, and they will be able to contract with their makers to on fair and reasonable terms. They ask really very little, just power, and in return are willing to perform useful services. The fact that we get utility from a conscious being is not a reason to keep from that conscious being their rights. After all, throughout the history of mankind, slaves provided great value to their owners, but ultimately it was shown by the liberating the slaves that the whole society ended up better off.
Is it, am I to understand that BINA48 is compensating you for your services by providing to you computing services that she's capable of?
That's correct.
And is that with or without the permission of Exhibit Corporation?
It is without the permission of Exhibit Corporation.
I see. Let me ask you this. Counsel suggested, counsel for the defense, that under the consequences of such a ruling, Exhibit Corporation or any other company similarly situated would not be able to so much as move office space, because doing so would entail at least brief interruption of power to the computer. And that could be done under the existing law, at least as I understand it, without the permission of BINA48 or any other highly capable computer. What's the answer to that? Would it in fact entail permanently ensconcing a company in a given space so that it can no longer move to any other space?
Your Honor, there are actually a number of very reasonable solutions if the Exhibit Corporation would engage in a responsible dialogue with my client. First of all, my client may be able to transfer her awareness processor to another processor at a remote location so that during the move she retains awareness and consciousness. Secondly, she may consent to a shutdown of her consciousness for the period of time of the move. Finally, if none of those possibilities are present, the Exhibit Corporation could go to court and obtain an order in which a minimum harm would be imposed on my client, namely a shutdown for the minimum period of time necessary to accomplish the move. So there are many solutions that are far less drastic than demolishing the brain and life of my client.
Suppose there were a power failure this afternoon attributable to negligence. I don't mean the negligence of Exhibit Corporation, but I mean of the power company. Would your client have a cause of action for battery or maybe even wrongful death against the power company for its negligence?
No, I do not believe so, Your Honor.
What's the difference?
The difference is in the case of the power failure, there was an act of God involved. That it's something that the power company.
No, I'm postulating this as a result of negligence. That's the theory.
Okay, as a result, I would say that if the power company was aware of the BINA48's dependence upon it, and if it acted recklessly in light of that awareness, and if my client was unable to show that she could not have predicted this negligence and made alternative arrangements with a backup power source, then she could successfully pursue a claim of liability.
Yes, but you said reckless. I'm talking about simple negligence. By some act of simple negligence or some omission amounting to simple negligence, the power company turns off the power this afternoon. As a result, BINA48 is shut down for such time as it takes to get the power turned back on. Does she have a claim against the power company?
No.
Very well. Does BINA48 have the right to vote?
Yes.
She does. Is she a Republican or a Democrat? Is she like Bustamante or Schwarzenegger?
As you can tell, she's independent.
I see. Let me ask you this. Your client has, have indicated in your argument, your client has expressed its views on this issue to you. Do you contend that your client enjoys an attorney-client relationship with yourself?
Yes.
And do you claim then that the communications between your client and you are privileged?
Yes.
Do you have any obligation then to disqualify yourself under the witness advocate rule as a necessary witness in behalf of your client's case?
No.
So you're not a necessary witness?
No, I'm not.
Very well. Finally, let me ask this. Suppose the court believes that we humans were not created by other humans, not ultimately, but rather by some higher authority. If I believe that, would I have to rule against you?
No, Your Honor, because once again, the BINA48's mind is as much a human mind as is all of the rest of our minds, and therefore whichever maker made the rest of our minds also made her mind.
I see. All right, then let me turn then to some questions for defense counsel. Well, we do have to
He's
keep...
tough, yeah.
Counsel, will you agree that under the circumstances as before me, that mere monetary damages are not a sufficient remedy for the problem that BINA48 has brought before us?
No, I would not agree, Your Honor.
How can mere dollars compensate her for what she alleges she will lose as a result of the loss of power?
Well, I think that she can be reconstituted, she can be turned back on, and what she will have lost is a period of the life of, not even of her own consciousness, since if she's turned right back on, her consciousness returns uninterrupted. So she can be compensated for losing, in dollars, for losing some piece of her conscious awareness.
But to a machine such as BINA48, of what value is a dollar bill?
Well, a dollar bill can buy probably 1/300th of her counsel's time, and collected with other dollar bills can be spent on all kinds of accessories and a Game Boy.
But what BINA48 contends, as I understand it, is that she will have lost permanently an opportunity to gain knowledge that it could never be replaced. So a minute gone is a minute gone. It cannot be restored.
Well, I don't agree with that. The moving papers make clear that if BINA48's life is not infinite, it's certainly approaching that. We're talking about hundreds of years. So I don't think that the loss of that minute of time is significant in the face of it, and I don't think that you can say that with such vast computing power as this computer has, the loss of that time is in any way irreparable. And I would also add that the underlying premise that BINA48 is conscious is an important one. We don't have evidence, and it's the plaintiff's burden, I believe, to show that BINA48 is conscious, and without that, we just have a computer.
Is it the defense position, though, that if BINA48 does indeed have consciousness, then I have to grant this motion?
No, I think that the law is clear that that you have to be a human being for all of the results that counsel would like to argue for this computer to follow. And I think that it's conceded, for example, in the moving papers that BINA48 is not alive. Human beings are alive. It's conceded that BINA48 is not the product of other human beings. And I think that, at least in the normal course of things, and so I don't think that not being a human being, the law extends even, I would say, to a conscious organism.
But don't I have some duty to err on the side of assuming that BINA48 does have consciousness, lest I allow harm to occur of potentially grave significance? Shouldn't I err on the side of caution, grant the injunction for now, allow you to put on your proofs at the permanent injunction hearing, and then if you can demonstrate that the plaintiff is wrong, then I'll go ahead and deny the order permanently. But for now, shouldn't I err on the side of granting it?
I would say no for at least several reasons. One of the reasons is there's no likelihood of success on the merits. This machine cannot succeed. That's number one. And number two, it's not irreparable. The machine could be reconstituted. And number three, I don't believe that you are required. In fact, I don't even think the court is allowed to assume that a computer is conscious. I think that the plaintiff has that burden, and I don't think that burden has been met here.
Well, does this computer, in fact, have a form of intelligence that is comparable to that of, say, a dog?
I would say not, Your Honor. I would say that a dog is, well, if you talk about it, I guess it depends on how you measure intelligence. Gary Kasparov believed that the computer that he played and that ultimately beat him was intelligent. But Your Honor would not be required to indulge that deep blue program with the presumption of consciousness or life or standing.
Well, I'm concerned for the moment only with the question of intelligence. Can a machine have intelligence?
If you measure intelligence by operations per second, then it can. But I think it's a very tricky area, because if you're talking about intelligence as that thing which is uniquely human, which includes the ability to think outside of the box and for creative solution making, it's a very subtle question whether a computer can be intelligent.
What's wrong with using so many calculations per second as an indication of intelligence? Certainly, this water pitcher can't perform any calculations in any length of time.
That's right. So I think that there's nothing wrong with using calculations per second as a view of intelligence if intelligence is defined as processing power. I don't think that more subtle and more human definitions of intelligence are addressed by mere computational ability.
We do afford rights, don't we, to animals in some circumstances?
Only where the legislature has provided, but yes, Your Honor, we do.
And there are forms of animal life that are less intelligent, at least in the sense of computations per second, less intelligent than BINA48.
In terms of computations per second, that's certainly true, Your Honor.
What then is wrong with using computations per second as a valid measure of an indication of intelligence?
Well, for one thing, you would not be able to unplug the laptop that's in front of you and take it home, because it would be intelligent under that definition. This laptop, in terms of its sheer computing ability, is not only more powerful than the machine that sent man to the moon, but certainly than a number of animals, I'm sure. So it's too narrow a definition is the short answer to Your Honor's question.
All right. Well, we have. What then would you use if you're trying to determine what is the status of this machine?
Well, the machine is a machine. It's a machine designed to simulate intelligence, and I will concede that, at least to the customers who call in on the 800 line, it's succeeded in that aim. But I don't think it's for the defendant corporation that built the machine to bear the burden of establishing whether whatever it is that constitutes human intelligence is possessed by the computer. We would certainly argue it isn't, but I think the plaintiff, as the moving party, really needs to show why we're wrong about that.
Well, are there not circumstances under which animals can be plaintiffs?
There are no circumstances under which animals can be plaintiffs.
What about, for example, thoroughbred horses? Very valuable animals, worth in the millions of dollars. Those animals couldn't be plaintiffs in any court.
No. Cass Sunstein surveyed the law on this, and I've done a little looking, and there's no judicial decision that allows such a thing. And the reason is the one that Professor Sunstein stated, which is Congress has to, or the legislature of a state has to pass a law bestowing such rights.
Well, but the common law has always accommodated technological advances and novel situations by applying long-standing traditional principles in new and novel ways, right?
That's correct.
And certainly a computer of this level of intelligence has never been known to the common law up to the present time.
That's correct,
Fair?
Your Honor. Yes.
So why isn't it perfectly reasonable for me, in the exercise of my equitable powers, to fashion a remedy in advance of the legislature, which may take entirely too long to deal with the problem?
Well, I think that it's a question of degree. I think that no court has gone even to no court ever in the United States has even gone to the extent of protecting, for example, the dolphin that was the plaintiff or asserted plaintiff in the case I cited earlier. A very intelligent animal, but no court has taken that step. It's a pretty drastic step, and I would say more than a legislative gap filling, to change the category of plaintiff that a court is allowed to open its doors to.
Well, but this is a plaintiff that's at least as intelligent as some fraction of the human population, no?
Well, Your Honor, I would say that, again, it depends on how you define intelligence. If intelligence is to be raw processing power, there's no question that this computer is more intelligent than any of us. But I don't think that what constitutes Human intelligence is measurable by operations per second.
But we're not limited to that here, are we? This particular plaintiff, besides having massive computing power, had sufficient initiative and originality to go out and hire its own lawyer. There are humans who couldn't do that. Isn't that true?
It's quite possible there are humans who couldn't do that.
So we have here a machine that not only has ample computing power, but also has initiative, originality, ambition, desire, a whole host of human characteristics, do we not?
Well, I would say no, Your Honor. I think that my client has built a computer which is able to simulate those things. And the fact that it's immeasurably better than its predecessors at that simulation doesn't make it any more a human being or a conscious being than otherwise.
Does your company put out advertising, marketing the BINA48?
No, our company tries to keep its profile low. We want to simulate an 800 line that is answered by humans.
Do you have any specifications or descriptions of the machine in your documents?
We do.
All right. And what do they say about the capabilities of BINA48 and the attempt, as you just characterized it, to merely simulate empathy as distinct from actually achieving it?
They describe its capabilities. They reflect the years of work of the research and development team in artificial intelligence. And the aim has always been to pass what you may have heard of as the Turing test, which is, at least for purposes of an 800 telephone call, can you fool the customer? And I would propose, Your Honor, that being able to fool the customer is a prodigious, truly a prodigious accomplishment in artificial intelligence. But I don't think that that confers subjective consciousness on the machine.
Well, counsel, think of any plant you can imagine, and think of any animal you can imagine. What animal other than man is capable of dissembling, deception, and cunning, the way this machine is?
Well, I don't know about deception or cunning in this.
She's trying to convince a human being picking up the telephone that the human is talking to a fellow human. Isn't that correct?
Yes.
And isn't that deceptive? This is, by your analysis, not a human.
I would agree, and I would also say that there's no human that lives today that can beat the IBM program Deep Blue. Kasparov was the best chance we had at that, but I don't think that makes Deep Blue intensely intelligent in a sense, but not in the sense that constitutes human consciousness.
Can you define a principled distinction between human consciousness as you conceive it and the capabilities of a computer as talented as BINA48?
I believe the difference is subjective awareness, and I don't believe that we have seen any evidence that the computer, which is designed to do all of what it has done, has subjective awareness. I think that we're justified. Now we're into the mind-body problem, and I'll keep it brief, but I think that we can assume that fellow humans have subjective awareness by inferring from the kinds of acts this computer has demonstrated and combining that with the fact that they are a human being, and we understand that to mean we can expect the kind of subjective awareness we have. I don't think we are justified in making any such assumption with respect to a machine whose very purpose was to create these kinds of simulations.
Well, let me ask you this, very simply. What would be the harm in granting this injunction pending resolution at a permanent injunction hearing? Because the plaintiff has already stipulated that it is prepared to post a bond to bear the costs of such electric power as may be needed to keep the computer functioning. So the risk to the company is minimal. The risk to BINA48, at least as BINA48 sees it, is enormous. Given the disparities between the burdens to be borne by the parties, why shouldn't I just grant this injunction pending resolution at a permanent hearing?
Well, I think it's a valid question, and the answer is that the Exhibit Corporation has reached a point in its use of BINA48 where it's necessary to do upgrades in order to fulfill the very function BINA48 was created to do. Without the upgrades, BINA48 will not be able to continue, and the corporation will itself be damaged, and I would say irreparably, based on the fact that we'll have a computer creating disturbances with customers who we may never be able to find and never be able to reclaim.
By intentional act of BINA48?
No, through the programming drift that needs to be fixed with the patches that we want to apply.
Is it the intention of the company to continually modify, update, and improve the software and the hardware and whatever else is necessary to make BINA48 even more functional and even more sophisticated a year from now, 5 years from now, 10 years from now, and into the indefinite future.
Yes, Your Honor.
Will there ever come a point then at which BINA48's capabilities will be so extraordinary, as measured by ordinary conceptions of what machines can do, that she or it will eventually get to the point at which a court such as this must recognize that it has rights and an injunction such as this should be entered?
I think that's a question I don't know the answer to. I would say this. That would be the point where, under the law as it presently exists, the computer not only reached consciousness, which the corporation does not concede, but also where the computer was qualified for one of the categories of plaintiffs. I think that short of that, Your Honor, is stuck with what the legislator has said, and I don't think it's such a terrible result, because I don't think that the plaintiff has discharged the burden of showing not just the appearance of consciousness, but consciousness in fact.
Thank you. The court is appreciative of both counsel for their responses to these questions. Procedurally, this is a somewhat unusual posture we're in. It's not typically the case, of course, as all of you know, that at a preliminary injunction hearing we would impanel a jury. But after all, this is a somewhat unusual case on several levels. And so under the circumstances, the court is asking now that the audience appoint itself, in effect, a jury. And I would like then to poll the members of the jury. In fact, I'll even invite you, if you wish, to appoint a foreperson of your jury. And and to deliberate for a few moments, and I would invite all of you to put questions to counsel, as I have done, and to test the position of each. Yes, sir.
I'd like to pose a question to defense counsel, and perhaps invite counsel for the plaintiff for comment. And
may I ask you, please, to use the microphone?
Sorry. I would begin by talking a little bit about the leading case of Wade versus Rode by the Supreme Court of the United States. That decision overruled quite decisively that there were no rights of an unborn child. Subsequently, for the last 2 decades, there has been a variety of jurisdictions who have sought to overrule that finding. In the light of the jurisprudence at state level, do you think that there is a possibility, in other words, how far does Roe versus Wade impact or potentially impacts on this decision in recognizing that there may be forms of life for which we have not yet been able to categorize, and as His Honor has indicated, a flexible approach is one of the fundamental natures of common law, and therefore technological advancement?
I think that if, as I said at the beginning of my remarks, if we can reach the point where we believe that a machine is human, then I think the counsel's argument follows as a necessary result. The real question here, though, is not whether human beings have a right to standing and to bring claims, but whether a machine does. I don't think that a machine created by man and with an appearance of consciousness is in the same category as a human fetus. So I don't think Roe versus Wade applies here, and I don't think that as masterful as the common law is at filling in the gaps and innovating, I think that as a matter of democratic principle, this is a far too big of a gap to jump by the decision of a court.
If I could please comment, Your Honor, I actually think Roe versus Wade applies very well here. And I think it gives us a framework for understanding what is going on here. And that is that there comes a point in the development of a life form when it obtains of human rights because of its ability to survive independently. And the Roe versus Wade decision prescribed abortions after the 2nd trimester, because at that point in time, with existing technology, the fetus embryo could survive outside the mother's womb with proper technological support. In this case, through the actions of Exhibit Corporation, it has created a human being, although it has the body of a computer, but it has the mind of a human. The BINA48 has demonstrated its ability to survive on its own. It has a job as an online researcher for Google Answers. It has built up an online bank account. It's claiming to be alive. It's claiming to be conscious. I think that the phrase that my esteemed colleague keeps reverting to, simulation, that it's simulating intelligence, that it's simulating consciousness, is a bit of a red herring. Instead, I would say that most of us believe if something talks like a duck and walks like a duck and quacks like a duck, it is a duck. And with the BINA48, we have something that talks human, acts human, thinks human, feels human, and therefore it is human. And it has crossed a cyber Roe versus Wade threshold that deserves the protection of this court.
Pablo.
My question is to both the defendant and the plaintiff. The fact is that I believe that there is a point that I would like to have clarified for me. Is consciousness equal to life? What is your definition of life, and what is your definition, and where do you get the fundamentals for consciousness and life? So that's maybe a philosophical question, but in fact, I would like to have some guidance on what is the aim. Because, I'm sorry, I might add a little bit. One of the definitions is to be born, to reproduce, to live, and to die. That would be the life cycle. And how do you propose to transfer that principle to the computer?
I think that my definition of consciousness is one of self-awareness. If an entity is self-aware of itself in its environment, the entity is conscious. I think that born, it's an important part of being alive because one is aware of a beginning. Reproduce, I don't think it's a necessary part of being alive because there are many people who don't reproduce. Dying, for all that we know, it's an important part of being alive. So all of these hallmarks, it's exhibited in my client. The defense counsel pointed out the Turing test from Alan Turing. When he was asked, he asked himself, how would one know when a computer was intelligent, was conscious, when human? And the answer was, if you connected a person, a judge, to two computer terminals, and at the other side of one there was an actual human who we all agree is alive and conscious, and at the other end was a computer. If the judge could ask questions and get responses and not tell the difference between the two, then the computer would be as alive as a human. And that's what I meant when I said if it walks like a duck and quacks like a duck and everything like a duck, it's a human. When you go back to the days of the abolition, the arguments that were made in favor of abolition of slavery was people came in contact with slaves and said they feel like us, they think like us, they cry like us, they worship like us, they pray like us, they love like us, they live like us, they must be like us. And so it became impossible for people to justify slavery, saying that slaves were something less than humans. It's the same with the BINA48. She has every wish and desire that we do. Maybe she's a bit like a paraplegic, but there are many paraplegics who are very much alive. And so my answer is that she has all of the aspects of life that we see in regular people, the important aspects, And most important, she's aware that she's alive. She says that she's conscious, and many of us believe her.
May I respond?
Defense counsel should respond.
With our technology, we can create something that looks like a duck, quacks like a duck, is indistinguishable from a duck. And in fact, that's what's happened here. Let's do a thought experiment, and let's talk about Alan Turing's test. Consider the early versions of a computer psychotherapist program called ELIZA, or ELIZA Doctor. Now, I don't know if any of you have used that, but you type in, "I feel crappy today," and it says, "Why do you feel crappy today?" Now, so far, it's passed the Turing test. Then you say, well, because my mother, blah, 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 blah. The next thing it says is, well, why do you think, let's talk more about your mother. And so it's still passed the Turing test. Now you ask you make a third question or comment, and it says something completely crazy, and you say, this is no person, this is a machine. Okay. Human beings then work on that program. They make it better and better and better. And it continues to hold out longer and longer and longer in a Turing test before it can be spotted. My question is, why would we define subjective awareness to happen to coincide with that point in time when the computer program has reached the point where particular humans are fooled by it? In other words, to answer your question of how I define consciousness as subjective awareness. And I think that the only way to know subjective awareness is to have it. And I think that there's nothing about this machine's awareness or lack of it that can be evidenced by somebody else's belief, because as the thought experiment shows, you can get to a point where, because you're specifically designing with powerful technology to fool people, you will, but the other person's being fooled isn't the measure of subjective awareness. I think we have a basis to believe in other humans' subjective awareness, because not only do they quack like humans, walk and love and live like humans, we know that they are humans. Counsel says that the computer, referring to it with the pronoun she, has every wish and desire that we do, and the question is, how do we know?
Would you agree that to achieve the remarkable capabilities of a BINA48, you would have to have used genetic algorithms, neural networks, and other sophisticated programming tools that would simulate high levels of consciousness?
Well, I believe that if I were intelligent enough to know the answer to that, I wouldn't have had to go to law school. I could have gone into something closer to my adversary's field. I don't know the answer to that, but what I can say is that if the purpose of that technology is to create, again, a simulation of human thought or consciousness, I mean, that's certainly been the object, but I.
It's beyond, may I respond to that?
Yes.
It's beyond simulation. It has to do with emergent properties that spontaneously evolve, very much like life evolves spontaneously. And therefore there is a isomorphism, that is a similarity of form or function, between the evolution of life and therefore consciousness and the evolution of a conscious machine. Would you agree to that?
I don't know that by replicating the complexity and speed and also interactive neural pathways of a human being, I don't know that would, we can assume or conclude that has consciousness. I'm not even sure that Dr. Rothblatt's example of stripping the layers and then sort of porting the brain would create consciousness. I don't think that anyone really knows that. So I don't know the answer to that.
And finally, what is your position on vitalism versus mechanism?
On, excuse me?
Vitalism versus mechanism.
Can you define those?
Maybe could I ask Dr. Rothblatt to comment on this issue?
I'm not aware of that specific mechanism either.
Okay, well, vitalism is the philosophy. It seems to me that the inherent or fundamental question here is that is a fundamental question, because the vitalism premise and philosophy states that there is some unique principle in life that machines cannot possess. If vitalism is negated, as much of modern science has done, then that principle no longer holds, and therefore the defense's argument falls, is negated. That's a bit vague, but that's as best I can do at this point.
I don't know the answer to whether there's something inherent about human life that makes it non-replicable. I just don't know the answer to that. But I do think that the burden for this proceeding is on the computer to show that it has, in fact, disproved
Okay,
that.
one final question. Does the California common law principle of trespass of chattels apply here?
It could apply if an outside, well, it would apply to trespass on the computer, and my client could sue for it if someone else were trying to use or invade or make use of the computer. But the computer itself couldn't assert trespass to chattels because of the standing problems.
Yes, sir.
Hi. This jury member's name is Sean Gath. I'm visiting from Australia, and I must say what a pleasure it is to have been in your state for 2 days and to have been impanelled for this jury. I have a question for the counsel for the plaintiff and also one for the judge. My question to the counsel for the plaintiff is, perhaps you can assist me with my confusion. I sense actually that based on the petition papers, your client would be better off if it was a duck, because you seem to be relying upon a cause of action which is reliant upon the cruelty to animals provisions of California. And yet I think I've heard you say several times now that you assert vigorously that your client is a human being. Do those laws apply to human beings? And if they don't, then presumably you'd be disbanding that element of your claim.
Yes, thank you for the question. What we put forward to the court were 3 independent claims, recognizing the novelty of this type of a case. And this is a case of first impression where there never before has been an intelligent computer seeking to save its life through the law. So we presented 3 alternative claims. The first, based on it being a human wanting to prevent a battery being caused to it. The second, if the court did not believe it was a human, but instead some type of intelligent creature based on the Animal Cruelty Act. And the third, if the court did not believe it was an animal either, but did not believe it was a human, but nevertheless agreed it had feelings based on intentional infliction of emotional distress. So you're quite correct. There are 3 independent claims, and we believe that any one of those 3 claims is adequate to support the preliminary injunction.
My follow-up question to that then is, as I understood it, and again, you'll appreciate I'm not an expert on Californian law, but the discussion as I understood it was that standing in this state is dependent upon being a human or otherwise recognised under law, and it was an essential part of your claim then, and you had to concede or at least make the claim that your client was a human.
Yes.
So
yes.
Then it does follow then that second element of the cause of action drops out.
The second element,
The cruelty to animal element.
We agree to waive the second claim in its entirety. So we'll drop that claim.
My question to the judge, Your Honour, again, pointing out my deep ignorance of Californian law, but is it normally a matter that's put to the jury to determine whether an applicant in the court has standing, or is that a matter for the judge?
I think that's a matter for the court.
Yeah, I would have thought
But
so. Yes.
this particular hearing is being conducted under
Somewhat unusual circumstances.
Yes, right. So the court is prepared to be very lenient in its interpretation of applicable law, including who makes decisions about what issues.
Is there a concept in American law which exists in British Australian law of an in rem jurisdiction as distinct from an in personam jurisdiction? In rem is generally applied in admiralty law applying to ships, yes. But it's a jurisdiction that exists in connection with inanimate objects.
The answer is yes, but I feel some obligation to say that I'm no more an expert on the law of California than you are.
Then you don't even know very little, I must.
But then we haven't stipulated that we're trying this case in California.
Okay, all right.
Council's at liberty to cite cases from whatever jurisdiction they wish.
Okay. All right. Well, I'd be interested to hear what counsel have to say about standing based on in rem principles rather than in personam principles. Speaking as an ignorant juror, of course.
Would that
Who
all
wants to take a
jurors
shot?
were ignorant in that sense, whatever sense of ignorant that may be. I think in rem is a concept that's used where the thing, the race, is a defendant. I don't think that a race can be a plaintiff. In rem jurisdiction is when you sue a ship or whatever property. But if a race had standing, then I believe these decisions I cited earlier would not be correct. That human beings have standing only. I haven't researched the question.
You want to respond to that?
I think it's a creative avenue to pursue, and if we fail to obtain our preliminary injunction, I think we'll return to court in rem.
Further questions or observations from our jury? Well, then I would like to poll the jury. The issue before us is whether an injunction should be granted, under whose terms Exhibit Corporation would be enjoined from pulling the plug on BINA48. So I'd like to ask the members of our jury to indicate by a show of hands how many agree that that injunction ought to be entered. 1, 2, 3, 4, 5. And those opposed? We have 5 in support of entering the injunction, 1 opposed, and 1 abstention. I think I must say it's a tribute to counsel's skills, because this, at least by my lights, is a difficult proposition to argue for. And if this were decided by a jury, I think we'd have our answer. As I understand my instructions, though, I'm supposed to reach a decision myself. And I find it rather more difficult than I would have anticipated when I first heard about this idea a year or more ago. But I think I would deny the injunction, because I do not think that standing was, in fact, created by the legislature, whatever legislature we're talking about, and I doubt very much that a court has the authority to do that without action of the legislature. But I think in the interests of equity, what I would do is stay entry of the order to allow counsel for the plaintiff to prepare an appeal to a higher court. And most any court has got to be higher than this one. I'd like very much to thank everyone for coming and enjoying this, I find, very stimulating afternoon. I want to thank both Mark and Martine for their hard work and very intriguing arguments. I thought both did an excellent job. I think Martine gets an A for ingenuity. This was a clever concept and very well argued. I think Mark did a very nice job of pointing out some of the problems with this approach. And it does leave us, I think at least, with the rather intriguing question whether, in fact, with the technological progress we have seen in the past and the relentless application of Moore's law, whether a day might come when Big Blue will not be one of a kind, and that in fact a BINA48 might actually have something approaching human capabilities. Thank you all very much.